We're back. We have 6 more to go, 6 big ones. Going back down to the northwest, upper northwest. King County, Washington, electronic court records with Barbara Miner and Mary Yu. Thank you both for coming.
Thanks. I'm Barb Miner, clerk of the King County Superior Court in Seattle, Washington, the 13th largest county in the country. Our court handles every type of case, from capital murder to neighborhood disputes, family law to truancy. My office serves 63 judicial officers, thousands of attorneys, litigants, pro se parties, title companies, the public, and the press, all of whom may need to file documents or need access to the case files. Our innovation is the Electronic Court Records Program we call ECR. What makes our program unique is that we did it in an environment that was resistant to change and absolutely reliant on paper. It's a fundamental change in how we conduct business and deliver services. It's different than other projects described here today, and it's more than other court scanning and electronic filing projects you may know of. It's a success for both the executive and the judicial branches of government. We developed a long-term, multi-stage vision that was formalized in a master plan, including image documents, all electronic access, electronic filing, and accessibility over the internet. We started first with imaging, converting documents we received daily, over 8,000 documents, into images. We also obtained a threshold change in state legislation to allow the official record to be kept electronically. In phase 2, we led our justice system partners from their traditional unquestioning reliance on paper to this new way, where the electronic copy would be the official record. This phase involved the judges, prosecutor, public defense, jail, and the sheriff. We asked each partner to show us how and where they use the court files, and we asked what it would take for them to use the files electronically. We listened to them, and then we trained their staff in the new methods, and we bought them new technology to ensure ECR would be a success for everyone. And as soon as everyone was okay, including the judges, the paper files went away. In subsequent phases, we developed electronic filing and internet access to case files. We found we had to address the tension between an open and transparent court system and the privacy of litigants. Throughout this project, we have molded and shaped state court rules, legislation, and national and state standards that enable electronic court records. We designed ECR to manage case files and to better meet the needs of the self-represented and those with disabilities. The effectiveness of our innovation is clear. We've met our goals, and we've repaid the county's $4 million investment in us, just as we promised. In fact, we've saved over $5 million in efficiencies so far. ECR has many other benefits as well. We've no more lost documents or files. Unlike paper files, manipulation, theft, defacement, and sabotage are no longer a worry. We have a backup system that never existed in the paper file arena, and security has dramatically improved. We've lived through an earthquake and a major system outage, and each disaster helped us strengthen and appreciate ECR even more. What we've learned in this project is transferable to other organizations that rely on high-use central court records. And now, for a user's perspective, Judge Mary Yu.
I'd like to address the significant impact electronic court records has had on one of the users, and that is judges. The import of ECR is evident in what we judges are supposed to do, and that is make good decisions in a timely manner. ECR has improved my decision-making and has made me far more efficient than I could have been in a paper record world. When I first came to the court, I had to use traditional paper files, and each time I needed to prepare for a case or a decision, I asked my staff to ask the court clerk, who asked the office clerk, who then asked yet another clerk to pull the file off the shelf and bring it to me, and eventually I got the file. On the other hand, there were times that I did not receive the file in time, and I still had to make a decision. Because we are also working on several cases at one time, there were times when my office quickly became a mini clerk's office with thousands of stacks of pieces of paper everywhere and files, and yet the fact is no one else could even use the file when it was in my office. Today, I can instantaneously review a court file on my office desktop, on the bench, or in my kitchen on a Saturday morning. I'm also electronically filing orders and decisions. Counsel and I can even have a work session where we are all looking at the same file at the same time. ECR is not only good for judges, but it's good for our entire system of justice, because access to court files is critical to tough decisions, and which I have to make, which affect a person's liberty or the placement of a child or the protection of a victim of domestic violence. Finally, as judges, we value ECR because it protects the integrity of our court records. Destruction can bring our work to a halt and risk due process, as we recently witnessed in the flooding waters of Louisiana. ECR is an innovation that can transform the judicial branch. It facilitates what we really are about, and that is the fair and efficient administration of justice.
Thank you. Ed?
Well, Your Honor, I guess you're not one of the judges who's insisted that those electronic records be reconverted to paper.
I'm not.
But I'm intrigued at this issue by the question of privacy and security. And Ms. Miner, you mentioned that you thought security actually had been improved. One of the concerns about other forms of electronic records is that they are easily disseminated. How did you improve security?
Our paper file arena, we had to trust, again, people who were supposed to have access to sealed files or confidential records. In the electronic, we have a role-based system that only certain people, certain types of folks with user IDs and passwords get access to those records. So from that security perspective, we feel much more secure about that in terms of who gets access, and almost exclusively that access happens in our office except for the judicial officers who are allowed to see those things in their offices. So we have control. You can't just come in and look at a sealed or confidential document. In terms of security of the record, the hard copy was vulnerable to so many things. People just, even by accident, writing on them as they get caught up in their work and looking at a document, writing on them. A lot of parties who maybe have not good intent, removing a document from the file, taking it with them. That's just not the case in the electronic world at all. So the security that we have in terms of once we have the document and once it's in the system, it feels 100% better to us.
All right, we have David, Bill, and Carl.
Are you sure that no courts in other states have done this?
What we find across the country is that there's been a lot of courts who've done an electronic filing project and an imaging project. And even in my own state, over probably 75% of the clerks in the state have converted their document to images. But what they haven't done is kind of what we call our second phase, our connectivity phase, where we involved our judges and our justice system partners, and we worked with them to give up their reliance on the paper. So in Washington State, we're the only clerk's office and court who has given up the paper version. So whereas these other courts have electronic versions of them, most of their customers still access the hard copy. And their clerk's offices are keeping dual modes of paper and electronic.
Bill?
I understand the system totally crashed for 5 weeks a year or so ago, and it's hard for me to understand how that didn't create a problem for you. I mean, how that was able to be worked through. How did you work through it?
It was very painful, very painful memory for me. It was, again, kind of comparing it to the paper. In the electronic world, we actually had a backup. Now, the problem at that time period had been that we are also working on our backup system, and so our backup system wasn't readily available as we had intended. Had this kind of major disaster happen in the paper file arena, say a fire or something like that, a flood for the building, none of those documents would have been accessible. In the electronic world, we were able to use our backup system on a limited basis to keep the courts that had calendars and high volume and criminal matters that were, our top priority going.
And now you have it totally backed up?
Yes, we do. We've much grown our backup capacity.
Fine, Carl?
I guess to both of you. Ed alluded to the fact that some judges in high-volume parts are now or still requiring you to, after you've imaged all of these and created electronic files, to reconvert them to paper. Why do they do that? What's the issue in the high-volume parts, and how are you planning to overcome that resistance, or should it be overcome?
I hope it'll be overcome. One of the most difficult phases of the ECR program was actually working with the bench and getting them to agree to work with the electronic. It took us 2 years, and we ended up coming to an agreement with the bench where we stair-stepped implementation, and little by little we converted them on different case types, starting with the case types that were least used by the bench and maybe were more used by the clerk's office. And as we stepped through the ones that were more heavily used by the court, that's where we met the most resistance. And in that arena, we came up with a protocol, an agreement with our bench. And certain documents we'll print for them every time. Certain types of documents we'll keep in hard copy. For certain calendars, like our family law calendar, which is really, you know, we refer to it sometimes as a rocket docket. It's so fast and really big decisions made about children. And we'll print for them, and it's still cheaper for us to print for them and provide that for them on a daily basis and more efficient than to keep those hard copies.
The time is up, but I want to ask you one last question. In trying to assess these variety of finalists that we see, I asked this question earlier, with so many systems going electronic, and that becomes the innovation that we see often, I'm sort of in my own mind looking for what's the plus beyond going electronic, and I wonder, is there any evidence here that this will improve the quality of justice?
Wholeheartedly, absolutely, yes. And that's because the sad reality is that judges are sometimes forced to make decisions without knowing the full record because we simply can't access them quick enough. When I describe the reality of having to ask a clerk to get another clerk to actually get the file, that's happening around the country in state courts every single day. And it slows down justice, but frankly, many judges have to make fast decisions. In those cases, you really don't have the time to wait. So the nightmare, of course, is always for a judge to say, but I didn't know.
Okay. That's very helpful. Thank you very much.